Hi, I'm Christina Callis, a lawyer in New York City, and I'm here with Janet Benshoof, the president and founder of the Global Justice Center. We're here to talk to you about women's rights and laws and potential laws that are impacting women in America today and how it fits into the international legal framework. And we thought that one of the best ways to talk about this would be to look backwards at the incredible the legal history and all of the fights that Janet has fought for women's rights through her many decades as a women's rights lawyer in America, and to sort of look forward and see how we could use all of her experiences to keep fighting the good fight.
Well, thanks, Christina. Let's not make it many decades. I mean, if you could tweak that a little bit, I'm still.
I mean, she's
strong.
only 32, so
Right.
it can't be that long.
Well, it's a very interesting time in history, and it's an interesting time in history for me because, of course, when I went to law school, there wasn't much talk about women's rights in general or international law in general. And now we have a situation where American women have fewer rights than women in many parts of the world. I mean, the rights we have are generally through statutes, not because we have some treaty or some constitution that upholds our rights. We have very few rights compared to constitutional rights of women in South Africa. We have even fewer rights under law, fundamental law, than women in Belize. So this is a time in history when we have to look back at where did we go wrong in pushing women's rights in America, and what can we do to fix this and trump Trump?
And I think a lot of people aren't even aware of where the United States fits into the world now as far as women's rights. It's sort of, we're learning about how bad we are in healthcare and how we're slipping on education, but I think this is a real opportunity to talk about how bad we are now on women's rights compared to some of our other developed countries, right? So, I mean, first, one of the great opportunities to learn from you is because you are, I think, not just in my personal experience, but you are one of the most foremost litigators in the United States for women's rights issues, right? So could you tell us some of the major litigation that you have fought for, I would say almost single-handedly in the United States regarding women's rights and abortion rights?
Well, I'd be happy to, Christine. I think it's important to point out in the beginning that there's a great myth in the United States, and that is that women have more rights than women all around the world. And that just simply isn't true. I mean, I think the most radical thing I could do for American women is just bring women from Norway over here to do a speaking tour in the Midwest. And I'm serious about that. I mean, we are a wealthy country, and women as well as men who are privileged enjoy great benefits, but we do not have a fundamental set of rights for women that all other developed countries have and most lesser developed countries have. So I'll go on from there to your question.
Could you just name some of the rights that women in Norway and other developed countries have that women don't necessarily have a right to in America? Just sort of spell it out.
Well, a lot of countries, like the Scandinavian countries, have really adopted the international standard of equality, which the United States rejects. And the international standard of equality is embodied in a treaty, although you can just have it as part of your national law or constitution. And that treaty is the Convention Against All Forms of Discrimination Against Women. Why that treaty is important is if it's made part of your national law, if it really governs your country, then any single law that disadvantages women, whether it's neutral on its face, like veterans' benefits, or whether it's really aimed at women, like anti-abortion laws, have to be evaluated under CEDAW, which is the acronym, and invalidated if they violate women's equality in fact or in law. And so that's a opposite of the United States standard of equality. So for example, abortion restrictions would be invalid in Norway. Women and men have rights to paid maternity leave, paternity leave, maternity leave, family leave. In Norway, there's equality in the military, and women are subject to the same conscription as men, so that the advantages that you get from veterans benefits, which are mainly men, those are not advantages in Norway. There are established quotas in the different parties to ensure that women have equal political power, which I think is really the very essence of equality, is that you have control over your reproduction, which means abortion rights, and that you have equal power, like half the women in the Pentagon. And so on those two indices, which I consider the most important indices for women's equality, the United States has no protections.
And I would add that I think you have a very unique perspective on this, because not only did you conduct some of the most important abortion litigation throughout the entire United States, but you did it with twins.
Well, yeah,
Yes.
so,
Unique perspective.
well, a lot of times my twins were less of a problem than my comrades and women's rights activists.
Who behave like
colleagues.
toddlers.
Well, no, I think there were distinct differences in the women's movement. There was a lot of political compromise that was taken in the early 1970s that has disserved women in the long term in getting their rights, and that is the kind of denial that women's equality had anything to do with biology, that women's equality wouldn't affect pregnancy discrimination, wouldn't affect abortion rights, wouldn't affect childbearing, any childbearing issues or family leave, that the definition of women's equality that was promoted by women in the Federal Equal Rights Amendment was that women had rights when they were denied a position that there was a male counterpart. So if women didn't get in a school where men got in, then that was sex discrimination. But if it was something particular to women, like pregnancy or abortion or, inability to do certain, let's say, artificial tasks to be a firefighter, those all were not considered sex discriminatory, and they aren't to this day, which is some 45 years later.
So why, Janet? Why doesn't the U.S. women's movement make a legal argument that these rights, or lack thereof, aren't sex discrimination?
Well, it's amazing from my viewpoint, because we made more rights that there was sex discrimination in the 1970s than we do in 2016. Even the women's groups who objected to the Hobby Lobby decision, which let a corporation have religious feelings that trump women's equal rights, all of
You said Trump.
well, that's an okay word in these times, but
It's a verb.
even in that case, I was examining the briefs, and they were so wimpy on saying this violated women's rights. It was more like it shouldn't be interpreted to let corporations have religious beliefs. So putting that aside for a minute, though, I think in the early 1970s, after the beginning of the civil rights movement, obviously we all know that the women's movement was a transformative movement that did change everyone's lives in America. And the kind of centerpiece of the women's movement was to revive the suffragettes' dream of a federal equal rights amendment. However, in 1970, they didn't really change the understanding of what equality meant from 1920, and they adopted a very conservative wording for a federal equal rights amendment, which would have changed our Constitution to guarantee gender equality. But the gender equality that it would guarantee was very, very narrow. It was only when a woman was like a man. So they did this really and to prevent forces against abortion from criticizing and not supporting the Equal Rights Amendment. So Republicans in the 70s who were anti-abortion, anti-Roe v. Wade, did support the ERA because they said that has nothing to do with abortion. And you had law professors writing law review articles with designated sort of feminists saying how this didn't cover anything to do with reproduction, and really providing a whole theoretical basis for limiting equality to when a woman just wanted to be like a man. And at that point in time, when I was challenging some of the early abortion restrictions, I wanted to say that not only did they violate the right to privacy under Roe, but they discriminated against women, and that they discriminated against the Equal Protection Clause. And I would get members of the women's movement saying, if I did that, I would defeat the ERA. And I couldn't raise sex discrimination arguments because people would then back away from the ERA. And to me, I think that, and Ruth Ginsburg agrees with me, that Roe shouldn't have been on privacy at all. It should have been that the right to choose abortion or childbearing is part of women's equality. It's part of our dignity as human beings. And that this right to privacy was shaky to begin with, and it has proven to be nonsense. I mean, I see signs at women's marches saying preserve Roe, I'm thinking, what is that about? Because there is really no fundamental right to make a choice under Roe. I mean, there's stronger scrutiny today of laws regulating trucks than there are laws regulating abortion clinics.
And so has the Supreme Court ruled on whether abortion restrictions are unconstitutional or sex discriminatory, that they actually do violate equal protection?
Well, actually, they've said that pregnancy-related laws are not sex discriminatory under the Constitution, because if men could get pregnant, they'd be discriminated against too. And this actually started in 1971 with a case called Geduldig, where there was a case challenging the legality of denying maternity benefits while giving everybody on the workforce medical benefits, and the Supreme Court said that's not sex discrimination because if men could get pregnant, then women and men would equally not
be
get
discriminated against.
Yes. And that then proceeded to Roe v. Wade, where that issue was not litigated. In Roe v. Wade, the argument was abortion's a fundamental right based on privacy, coming out of a lot of the early contraception cases. So it was felt that that was the strongest argument to make at the time, which it might have been, but it was not the right argument to make at the time. There should have been a very strong argument that it's sex discriminatory, but there wasn't. And part of the reason there wasn't was that to say abortion laws were sex discriminatory would have hurt the ERA movement, which was at that time had passed Congress and was trying to get enough states to ratify that there would be a constitutional amendment. So in the McRae case, which was in 1980, which was a case of mine, we challenged in a federal class action the fact that the Hyde Amendment removed medically necessary abortions from Medicaid women, whereas men got all the medically necessary procedures they would need on Medicaid. So there was one procedure, and I'm talking about medically necessary procedure that for women was removed, and that was abortion. And we did make a sex discrimination argument, although because this was a Social Security program, it wasn't so straightforward. And basically the court ignored that, but the dissent did start talking, Brennan and Blackmun, about how this was a discriminatory on women. They didn't say it violated equal protection, but that it was discriminatory. But later, challenges to abortion statutes in the Supreme Court didn't even raise that they were sex discriminatory. There was a lot of impact on women language, or, hurts women or discriminates against women, you see that, but not that this was unlawful under our Constitution. And in fact, after the Thornburg case in the Supreme Court, where the Supreme Court had been changing, and it was thought that the next case would overturn Roe, I think that was in 1989, states started passing abortion ban laws in order to test whether the court would overturn Roe. And 3 states, and 2 states and 1 territory, which counts as a state under our federal Constitution as far as law, Guam, Louisiana, and Utah, all passed what is essentially were essentially abortion ban laws. And I was the lead counsel in all 3 of the cases and defeated those laws. So in the 3 cases, all were challenges really to Roe to see what the Supreme Court would do with a changed lineup. And Utah was a very unusual case for me. Utah is a very unusual place. And first of all, they passed this law banning abortion without ever looking, and it was a criminal law, without ever looking what the sentence for that law would be. And as I was drawing up the complaint to challenge this law before it went to court, I kept looking to see, well, what's the penalty? How many years in prison?
Because it was a criminal law?
It was a criminal law, but I couldn't figure out how many years in prison the woman and the doctor. It was a criminal law on both the woman and the doctor. So as I was leafing through the penal code in Utah, I noticed that Governor Bangerter, who was the person I was suing, when he was in the legislature just 2 years ago, helped amend their death penalty statute. So I just happened to look that up, and I saw a bingo, which is like an insight. I saw that it covered illegal abortion. They had forgotten about that when they passed the abortion ban laws, so essentially the penalty for a woman or doctor who performed an abortion in Utah was the death penalty. So I couldn't believe this. I mean, it seems so like the death penalty for women, so I quickly looked up how do you kill them, and it was mostly a firing squad. So I called one of my biggest donors. I was at the ACLU at the time, and I said, Frank, listen, with your money and my idea, we can make history. And he thought this was a great idea. So we decided to have a full-page ad in the New York Times. And we had a picture of a firing squad, and we had a picture of a woman who had an abortion, and we had guns pointing at her, and the ad said, they really know how to treat a woman who has an abortion in Utah, shoot her or execute her. And so this was really revolutionary. It went on all the airways, it went on all the television news programs in Utah. And the governor said, whoa, this was an accident. And he said, I was just trying to protect little girls from being forced to have abortions in this law. But in any event, the governor immediately convened the legislature, had to pay all this money because they only meet every other year, convened the legislature to amend the statute just to put people in prison and not to kill them. So that was kind of a very good public relations tactic in the beginning. The other interesting part of that case was that I framed the complaint, of course, if Roe was overturned, that there were other constitutional reasons to overturn an abortion ban. And one, I put in the 13th Amendment, slavery, that imposing this on a woman and taking over her body violated the 13th Amendment. And the other argument I made was that forbidding a woman from having an abortion, forcing her to become pregnant, which is dangerous, and to become a mother, violated her right to equal protection. It was sex discriminatory under the 14th and 5th Amendment. Well, lo and behold, the judge, the federal district court judge, sanctioned me under Rule 11 for making a frivolous argument that an abortion ban was sex discriminatory. Now, I was delighted. I mean, I could not believe he would do this. And I knew that that this would be a great kind of political ploy to show America and American women that we had gone so far that they considered saying that abortion laws were sex discriminatory was sanctionable. So I appealed to the 11th Circuit, and I had a wonderful time writing the brief. I argued that Ruth Ginsburg testified that equality or sex discrimination would have been a favorable basis for, instead of privacy in Roe, in 1992 in her confirmation hearings for the Supreme Court. And I cited to two professor friends of mine who wrote on this issue of equality and privacy and got tenure at Stanford Law School. So I said, well, if people can get tenure and get on the Supreme Court with this argument, why is it frivolous? And of course, it was a woman judge on the 11th Circuit. She wrote a very hilarious opinion reversing the judge. And I immediately took it to Ruth Ginsburg, and she thought it was hilarious too. And so, as funny as that episode is, it kind of just shows you how far we've come in this country, that his decision was even treated seriously, that it was frivolous.
And one of the points you touched upon is public relations and sort of how to play upon the public. So taking out a full-page ad in the New York Times that made the governor of Utah look really, really bad, although it seems like he kind of did that on his own as well. I think you have used similar tactics in some of the litigation in other states, and I think it's important to note that that is also an important and effective way of turning the tide as far as American opinion goes in some of these instances, instead of playing down the discriminatory effect of some of these laws, right? So I was just wondering, you also mentioned Louisiana and Guam, where I believe you were arrested. Can you tell us how public opinion and your playing upon press releases or news helped you in any of those cases, or was part of your strategy?
Well, I wouldn't overestimate the impact of this. I mean,
Mm-hmm.
I think part of it is just my personal satisfaction. Because when I first came to the ACLU to direct the Reproductive Freedom Project in 1977, I saw that all these cases were Jane Doe, and I thought, what is this Jane Doe stuff? I mean, that's so wimpy, right? I mean, a Jane Doe seems this nameless victim. So of course you have to use a pseudonym because, women could get harassed, and it is very private, and you would never have clients. So instead of Jane Doe, I named all of my cases after women heroines, and I gave my women clients the option of various strong women, most of whom they'd never heard of. But, so my very first case was Emma G. after Emma Goldman in Louisiana, and then followed by Margaret S. for Margaret Sanger, and so on and so on. All my names. And then when things got really dicey with abortion, instead of women heroines, I got desperate and I had like Hope versus New York. But for my challenge in Utah, I decided to name, and she agreed with me, she loved it, the plaintiff to use the name Jane Liberty. Therefore, the caption of the case would be Liberty versus Governor Bangerter. This drove him batshit. I mean, so he had all his lawyers sue me to change the name, of which I wrote another brief showing how all these Indian names, like Bigfoot versus this, or I said in history you can pick your name, and some names are like that. And it said that to be Liberty versus Bangerter subjected him to public ridicule, which of course maybe it did. And so I was forced to change the names, so the case went on as Jane L., which I would describe in the press as Jane L., formerly Jane Liberty versus Bangerter, which I put in all the press releases. So that's just an example of kind of thinking about how you structure a case to make the women stronger, especially when rather than anonymous, although I don't think that many people picked up on the women, the different pseudonyms. But in Louisiana, when I approached the ban case, there was another angle that was very interesting, which was they really defined abortion to cover birth control. I mean, they covered it the moment of, they defined it very definitely as almost preconception, you know, and so I thought long and hard about that, and I talked to my staff and I said, you know, I think we should take a different approach in Louisiana. I think we should challenge the Louisiana abortion law on the basis that it violates the Food and Drug Administration Act. And they said, what? I said, well, it really prevents the use of birth control pills and IUDs, and courts are supposed to look at statutory issues before they look at constitutional issues. So we won't even go to the Constitution. And everybody said to me, well, you can't do that. You're challenging an abortion ban law based on the FDA. I said, yes. They said, well, why don't you put it in a footnote? And now that is a buzzword that drives me nuts, because whenever I have a good idea, they tell me to put it in a footnote. And I hate this, put it in a footnote. It should be your lead argument, so I made it my lead argument. And they took it seriously. I mean, they did. And so I made it very serious. I went on how it was a rule of construction. They had to look at the FDA first, forcing them to look at what this meant about this egg and sperm, considered to be an abortion. And I had a Fifth Circuit argument about this, and what my plan was really that they would so not want to go there and say it violated the FDA, that they would be favorable in my constitutional argument. And so that's exactly what happened. In fact, the opinion went on in great length saying why they weren't addressing the statutory issue first in this case. Not dismissing it, but saying in this particular case we're ignoring that rule of construction. So the strategy did work. And Guam, of course, is a different situation, because when Guam passed a ban law, I didn't even know Guam existed. I didn't even know what it was or where it was. I didn't even know the United States had territories besides the Virgin Islands and Puerto Rico. And so I learned on a Thursday from a phone call from Guam that the governor was going to sign a ban law on Monday, and that Guam was part of the Ninth Circuit, and therefore a law in Guam could go to the Supreme Court and could overturn Roe. They asked me to come to Guam, and I said, fine. I thought it was in the South Pacific, but turns out it isn't. It's down by Japan. But I got on an airplane and started reading a huge notebook people had put together about the kind of legal structure of Guam and how it's a territory, but you could still challenge it, and that I should talk to the governor on Monday and try to get him not to sign this law, which forbid anyone on Guam from speaking about abortion or performing an abortion. Criminal. And of course, Guam is an isolated island. I mean, Hawaii is the closest place to go to, and it's 6 hours away, and Japan is 5 hours away. So when I landed in Guam, I met the woman lawyer who had asked me to come, Anita Areola, who has become one of my dearest friends ever since the day we met. And it was all very complicated and very island-like. For example, her mother was the person who introduced the bill in the legislature, being a senator, and her mother called the Archbishop, it's a very Catholic island, and he came on the floor of the Guam legislature and said any senator who voted against this bill would be excommunicated, which is rather blatant. But Anita, met me and arranged that I talk to the press on Monday at the press club about how this law violated the establishment of religion as well as Roe and privacy and everything. But before I could do that, the governor signed the bill, and it was scheduled to go in effect in 4 days. So Anita and I decided to stay with our schedule and go to the press club, but this time we would explain what the law did. And I decided on my own I would not only explain what the law did, but how women could get around the law, which was effective then, but somehow I don't remember the exact details, but I did get up and I explained to women that they could go to Planned Parenthood in Hawaii, that if they had, there were 4 doctors that did abortions, but if they, and at that point, Anita got a call from the Attorney General, by the Attorney General, who said that I was under arrest for breaching the law, but that the governor didn't want me to be brought into court to be arraigned because I was such a nice lady, and there were too many drunks around till 5:30. So I was to come at 5:30, and I wasn't ever arrested, even in the 60s. I didn't know what to do. Like, was I guilty or not guilty? You know, like, I did it, but, you know, what? And so Anita would be my lawyer, and this was in the afternoon. I thought, what do I wear? What if I go to jail and I don't have any, like, the right clothes or something? And she said, don't worry about it. We're the same size. My dry cleaners is delivering all my suits to your hotel. And then I thought, well, what if I need bail? And so, and you know, I have a cash card, but I only had like $500. She said, don't worry, the doctors are coming down with briefcases full of money. Plus, she said, you know, my uncle owns the Bank of Guam, so they're going to stay open in case we need to go there. And I thought, oh, this is amazing. So I put on my little new suit from Banana Republic, orange. And meanwhile, in the 3 hours before this happened, Guam women got organized. And so they brought in busloads of people, like all disabled people and older people, and they had t-shirts made very quickly, Free the Guam One, that was me. And of course, so I didn't know what to do, and then there were like nuns and priests outside yelling at us, but there were all these Free the Guam One, and I said, Anita, who's going to be the judge? She said, well, it'll either be my cousin or my uncle. I said, really? And so we went in, and the first judge, who was related to her in some way, took a look at the courtroom and said, I recuse myself, I can't deal with this. So he left. And then somebody else did the same thing. And then I got arraigned and out of my own recognizance. And meanwhile, it was total excitement. The New York Times called, and People magazine called, and there were a big story in the Times, the ACLU lawyer arrested in Guam. And I had made the sentence that for women, I had made the comment, for women, this is Pearl Harbor for women. Now, I got a lot of criticism from Asian groups for that, although I don't really understand why. But in any event, the newspaper said this was the biggest story they had since World War II. And so I was sending dispatches to the Times, and as a joke, I sent to my friend who's a clerk in the Supreme Court a pro se petition, and he said he put it in the pro se pile to get released. I didn't have to go to jail or anything. And then we started putting together a federal challenge, because there is a federal district court judge assigned to Guam and to the Mariana Islands next door, well, not next door, but the next island over, and he flies between the two. And I said, well, this is a Reagan appointee, this Judge Munson. And Anita said, well, don't worry, he's a surfer, it'll be fine. Wow, I didn't know what that meant, but it was fine. And so a lot of women came to her office, and I decided to have a woman from the Navy base, our Navy base. And I found a woman from our Navy base, and of course I didn't know what pseudonym for her, so I called her Betsy Ross. So we had Betsy Ross, and then I thought, well, if we're making this religious claim, both free exercise and establishment, I also found a Jewish woman on Guam. This is not easy. And then I got an Episcopal priest to be the plaintiff, who was thrilled because the island, he has so few parishioners, but the Episcopal Church had a great stance, and he was just thrilled he was going to be a plaintiff, and he was calling his supervisors in the United States and the bishop, and they were all going to send in people to help him. And so this was all going together, and we put together a complaint. And of course, the case was right because I had been arrested. And Judge Munson flew in, and we got an injunction, and the women there started a pro-choice organization. And it was all a very family affair because everybody seemed to want to be pro-choice. I mean, we were recognized everywhere we went, Anita and I, and there was Miss Guam, Miss America contestant, and her words when she was accepting the nomination was, "I'm Miss Guam and I'm pro-choice." So I think, somehow we kind of got the hearts and minds of the people.
Yeah.
I did fall in love with the people of Guam.
Yeah.
I mean, the Chamorro was the native language of the native people, even though my lawyer Anita, had gone to Georgetown Law School and had worked for equal rights advocates in San Francisco prior to this, and so we just had a great time working on the law together. And I learned a lot of law, like what an Article 4 court is and Article 3. But it was also amazing on the human dimensions on a very small island. I realized, first of all, they had restaurants totally devoted to Spam, as the food group. And the other thing is, everyone was so intensely interested, like I would say, I don't know where I'd park my car. And Anita would call the police chief and he'd say something like, "She left it outside the Dairy Queen." And so it would be like everyone. And Anita was assigned protection because she was getting some threats.
Wow.
And so, unbeknownst to us, it turns out the police chief decided to protect her himself. And she lived in a little house on the south of the island, not where I was in the main town. And it turns out she heard this rustling in her bushes the night we got the injunction. She went out with her machete and almost decapitated the chief of police. And so we agreed that she shouldn't probably do this machete thing, like it might distract from women's rights and abortion. And I think it went up to the 11th Circuit, and the district court judge awarded triple attorney's fees for her still representing the women of the island, which, for those of you who are lawyers and know about attorney's fee statutes, to get treble attorney's fees, except in antitrust, is very, very unusual. And the Supreme Court declined to take the case, so we had the victory upon a strong dissent of Scalia, who wanted to take the case. And so that's how we got the 3 ban laws defeated in their own very eclectic and iconic ways.
So Janet, you said that basically we don't have a Roe v. Wade right now. What do you mean by that, and where is this taking us for women in America right now?
Well, by that I mean that in 1973, Roe v. Wade was a historic milestone in that it declared that the right to make the choice to have an abortion or to have a child is a fundamental right. Now that means something under U.S. law. A fundamental right is your right to vote, or your right to free speech, or your right to practice your religion. And fundamental rights get extra special protection by our Constitution, and really the presumption is that that right prevails over restrictions. You have to overcome the presumption. And really, the central part of a fundamental right is that the government has to be neutral. The government isn't supposed to bus Republicans to the polls and not Democrats. The government isn't supposed to, fund the Catholic Church, but not the, non-believers or a Jewish synagogue. And that kind of that fundamental core of what constitutes a fundamental right was gone from Roe by 1980, in 7 years. And that is, starting with the McRae case on Medicaid, the Supreme Court said, well, when it has to do with funding, the government doesn't have to be neutral. They can use money to push the idea that the fetus is to be preferred over the woman, that the woman is to be persuaded against abortion and not be funded for abortion, so that the government could take an anti-abortion viewpoint with its money, but not with its criminal laws. And 7 years later, they said, well, they can take a viewpoint with their criminal laws also. And that as long as the law doesn't unduly burden the woman, they can be anti-woman, pro-fetus. And that is not like a fundamental right at all. And so, whereas we have this minimal Roe now, or this Roe light, this twisted sister of a Roe, it's not what we had in 1973. And there are probably 500 criminal abortion statutes and civil abortion restrictions on funding that would be unconstitutional under the 1973 Roe, but that are being enforced today. So if we had the 1973 Roe today, there'd be, and it was enforced, there'd be, equal Medicaid funding, there wouldn't be these restrictions on foreign aid and abortion, there wouldn't be the kind of parental consent laws and, doctors' restrictions and hospital burdensome restrictions, all those would be out. But that's not the case.
So that's really depressing. So Janet, what would you say the next step is for the women's rights movement to fix that problem, to take back women's rights, women's abortion rights? What do you think the best strategy is now?
Well, I think taking back abortion rights is the phrase you use, but I think the way we got abortion rights in the first place was inherently weak and doomed to fall, and that's the right to privacy. I think the women's movement has to look at history and be bold. I mean, in 1971, they were so afraid of abortion that they took it out of the Equal Rights Amendment. We have to say women's equality and women's right to non-discrimination based on sex means that abortion laws are invalid. Now, it's hard to say that under our present Constitution, given the Supreme Court lineup. But the United States could ratify the Treaty of Convention against all forms of the elimination of all forms of discrimination against women, or CEDAW, and CEDAW would, if implemented, impose that standard on American laws and invalidate abortion restrictions and restrictions on pregnancy discrimination, restrictions on removing contraception from the Affordable Care Act, or the remove what Trump is trying to do, because CEDAW says every single law that disadvantages women, even neutral laws like veterans discrimination, veterans benefits, has to be strictly scrutinized, and really it would invalidate all these. So American women need CEDAW. American women have less fundamental rights over abortion and other issues than rights of women around the world. A teacher couldn't be fired when she got pregnant and she wasn't married from a Catholic high school in India because of CEDAW. And that would not be the case in the United States. The CEDAW says that religion and culture cannot be used to undermine equality. Therefore, this Hobby Lobby guy, this corporation run by people who are anti-abortion, anti-contraception, that would be a frivolous case and you'd get Rule 11. They couldn't have even filed that. It wouldn't have even survived a motion to dismiss for failure to state a claim, because the claim there, really, basically, when you get down to it, is that religion trumps women. Takes precedent. If you assert you have some religious belief against a woman exercising rights, then you can deny her those rights. Yet that argument, of course, never was made, and even the women's briefs submitted as amicus in the Hobby Lobby case tiptoed around, saying this hurts women, this discriminates against women, but there was no argument that religion should never take precedence over equality or cultural norms. So the CEDAW committee that governs really states' adherence to the treaty has made very strong general comments that you can't use culture and religion as excuses. And you can't use them because they're in your constitution, and you can't use them because they're in national laws. So the laws that were depended on in the Hobby Lobby case was the Religious Freedom Restoration Act. And that law, the way it was being used, would be invalid in that use if the United States implemented CEDAW and guaranteed true equality for American women, which they have never had under law.
So where are we on CEDAW? Is there now a movement to ratify CEDAW? Is it gaining momentum? Has it fizzled out? What's going on?
Well, there have been movements, very strong movements, to ratify CEDAW. President Clinton presented CEDAW to the Senate. President Obama said ratification was a priority. But the kind of proponents of CEDAW made arguments in which I would argue against ratification because it would do nothing for American women and would hurt women overseas. Now you might say, what do you mean by that? Mm-hmm. And what I mean is, the push to CEDAW in the United States, and you can see this just by Googling it, is made on arguments that are the worst sort of American arrogance and kind of take away rights from women. Basically, our argument is we have all the rights in the world, but we need to ratify CEDAW to show the United States is on the side of countries that have ratified CEDAW, and we need this to help, like, Afghan women prisoners, yes, not American women, and that it would never. We're not going to implement it here. It needs some special steps to be implemented, which is not true. So it wouldn't affect any of our laws. Especially it wouldn't affect any abortion laws. It wouldn't affect anything here. So I'm thinking, well, why do we need it then? And we're winning around the world in arguing that CEDAW defeats abortion laws. Why do we need the United States making a big statement that it doesn't? Mm-hmm. I mean, if an American CEDAW didn't affect the core of women's inequality, which is inequality based on her biology, getting pregnant, not getting maternity leave, not getting abortions, what do we need it for? Those are our biggest oppressive laws. Those are what's in the paper every day, whether it's an abortion law or whether it's the Affordable Care Act or whether it's Planned Parenthood going to be defunded, holding things up. I mean, those would not be there if we had CEDAW. So I think what we need is not a twisted sister CEDAW like being proposed. And even when Clinton proposed it to the Senate, it came laden with an agreement from the women's movement that they would say this doesn't affect abortion in any way. It's neutral on abortion. Well, CEDAW doesn't say anything about violence against women either, or domestic violence, but it's not neutral on any law. It applies to every law, and so this was a very sleazy way of trying to say it would do nothing and not get anti-abortion proponents to be against CEDAW. I think we need CEDAW because we need CEDAW to guarantee all equality, starting with the core of equality, which is equality over our bodily dignity, over our reproductive future, over our rights to live our life as mothers or not mothers.
Great.
And I hope that this Trump era of oppressing women in ways we've never seen before will wake up women to the fact that human rights are needed here in America. They're not for other women. They're for us. And we want them here.